Hello, today we talk about what inventions can be patented. So, perhaps the easiest thing to get started is to talk about what has been found to be patent ineligible. So anything to do with the laws of nature. So for example, E equals mc squared, or some laws on natural phenomena such as gravity and electricity, that cannot be patented. Now, how you apply that law of nature into an equipment to improve its performance is a different story. You can patent that, but just the law itself, you can't. Next is natural product. You cannot patent a product that's already existing in nature, such as minerals or plants. Those cannot be patented. You can also not patent abstract ideas. So ideas that are not tied to specific applications or implementations, such as mathematical formula or algorithms, those cannot be patented. And this is applicable in particular to software inventions. So the way you get out of the abstract ideas, you focus on your particular implementation, how you've made it more efficient or runs faster, or providing higher quality output. So that's the way you get out of the abstract idea rejection. Literary, dramatic, musical, and artistic works, those cannot be patented, but they can be protected under the copyright regime. Performance of a performing artist similarly cannot be patented, but can be copyrighted. Inventions that are offensive or immoral cannot be patented either. So for example, weapons of mass destruction, or things related to, let's say, a particular race, those things cannot be patented. Nuclear material cannot be, you can try for patenting nuclear material, but it is likely to be diverted into a special evaluation, special regulation by the government on nuclear inventions. And then, certain types of software that if it's too high level, like an abstract, it can be analogized to an abstract idea, and similarly, is not eligible for patent application. So, those are the background you have, and with that background, we now can try to look at what is patentable. So, to qualify for a utility patent, the invention must be, number one, new and useful, meaning it's not disclosed anywhere in the world. In the US, we have a 1-year grace period. So it is possible that if you accidentally announce it publicly to the world, you have 1-year period to capture it. However, you may have lost your right overseas, such as, let's say, in China or in Europe. The invention must also be novel. It must not be identically or substantially similar to an existing invention. The invention must also be non-obvious. It must be something that is not obvious to one skilled in the art. For example, if you're doing an application that's, adding 1 to 1 to equal 2, it would be potentially be rejected as being obvious. But however, somehow your invention is combining 2 parts and the result is triple the efficiency, then that is not obvious. So, and then another requirement is that the invention must have utility or be useful. It must have a specific practical application. So when you apply for these patents, another requirement is that you have to describe and illustrate the operation of the invention sufficient for one skilled in the art to implement and to use. So i.e., part of the requirement of the patent process is that you teach others how to use your invention in exchange for the 20-year exclusivity that they give you. The invention must be your invention. You can't be copying it from other people. That, I guess, is fairly obvious. So those are the requirements for a utility patent. What is the requirement for a design patent? To qualify for a design patent, you must be new and original, similar to what we discussed before. Particularly in a design patent, you have to have ornamental characteristics, i.e., the design patent is primarily for the purpose of the look and the feel, the ornamentation, and it cannot be dictated solely by the function. That would be the domain of a utility patent. The invention must be applied to an article of manufacture, such as a product or packaging. And in the application, the design must be adequately described and illustrated. And again, it must be your invention in order for you to be granted a design patent. And so in general, if you have a new idea that has useful functionality and it is novel and non-obvious, you can get a patent. So that's the criteria for you to keep in mind as you move on to your journey of patenting your invention. Patent PC exists to help inventors obtain the patents, and so we are perfectly happy to have a free discussion initially, an initial call with you to discuss whether or not your idea is patentable. Please feel free to email us at btran@patentpc.com or visit our website, patentpc.com. We look forward to talking with you. Thank you.